How's everybody doing? Oh, got a couple more coming in here. So this class, I guess you say class, I'm gonna say discussion because you know me, I'm not quite as formal that way, but really just wanted to show, and for some of you, you're gonna know how to do this already, but just to show you where to find things when you're looking at ownership for a property, whether it's a seller or if it's a buyer making an offer, you know, looking at the listing side, how to find who the owner is and who really can sign. Because as you know, I've been harping on the whole name thing for 2 years now about confirming who actually can sign and do we have the proper documentation and is title correct and all of those things. It's become a real challenge. I mean, it's a lot of there are a lot of transactions that are happening while that we find out there's an issue while we're in escrow. And then there's the delays. And then in this market, you can imagine everybody's frustrated already and it just can get really ugly. So Jody's on here with me as my little backup. Thank you, Jody, because I knew she could chime in from the title side. But I think the biggest thing to remember is we've talked about in the names is the if it's a trust, if it's a power of attorney, if it's an LLC, those kind of things. And we have those sample signature blocks that I've mentioned a million times, but everybody knows where to find those, right? In working docs of Sky Slope. There is another one that Jody provided that I'm just going to mention before we dive into how to find these things when you're searching online. Let me see if I can share my screen. Can I share my screen? Here we go. So Jody provided this, and I've sent it out once in a broker blast. Can you guys see this screen? With these entity transfers, and basically what this is it shows for if it's a power of attorney, what is needed and how they need to sign. So it's really handy to know what you need to start prepping the seller for. For example, if you go on a listing appointment and they're a power of attorney, okay, let's talk about that. Let's confirm what kind of power of attorney you have. I usually will send those to title ahead of time before we even go on the market kind of a thing. I think that's just a great way to have the title company confirm if that power of attorney can be used. And here's the biggest reason why is what I've run into in the past, and Jody can probably share a million stories, is it wasn't the general power of attorney that allows for the transfer of real property. So they can't sign for that. There are different kinds. There's a general, there's a specific. Sometimes title companies will want a specific. Jody, if you have any input on that, let me know. But it has to be, and then we run into one recently where it was a power of attorney from Georgia that they needed to redo here locally. So, you know, things like that, again, I just think it's easier to send it to your title company ahead of time, let them review it and make sure you have what you need. But this for the trust as well, for LLCs, partnerships, and then potentially a deceased owner when you are dealing with a trust, maybe you have a successor trustee or someone signing what will be needed. So it's really handy. I think it's in the working docs of Sky Slope. If it's not, I'll make sure it's there today. And I will also send this out to you guys via email again for reference in case you didn't have that from before.
So something I just want to say really quick on power of attorneys.
Yeah.
Those are typically the ones that always cause us the most headaches. So with a power of attorney, you need to make sure that if it's an Arizona power of attorney, a witness has to also sign and have their signature notarized on that power of attorney. And it cannot be anyone related or in any way to the transaction. Can't be a child. It can't be an agent. It has to be somebody completely outside of the scope of the transaction. So that's a big one that we don't see, that people think, oh, well, it's a power of attorney, it works. Well, not in the state of Arizona. And that is specifically if it's an Arizona power of attorney. If it's an out-of-state power of attorney, we do have exceptions to those because different states have different laws that they go by. And so we do get those to our underwriter for them to approve. Like I had one the other day from, I think it was Iowa, and it didn't have a witness. The other item that it needs to have on there, it's a specific word. You want to make sure that it has the word convey. that they can convey ownership. Not they can sell a property, it has to have the word convey. So just something that you might want to also take a look at and just see if you can find that word on there, because that is a big one that I think I've gotten away without having the word convey once on all of my POAs.
Thank you. I
Yeah.
appreciate that, because those are little things, little nuances that, again, where I rely on you guys, you know, to tell us those things and what we can use, and better to find out ahead of time than when you're in escrow and you can't get someone because now they're out of the country or whatever the situation. I mean, we've run into a million of them, but Danielle and Lynette, either one of you want to jump in? You mentioned you have a couple stories you want to share on that.
I'll go first.
Okay.
So on, I had, my biggest one was, and I had submitted it to title first, just to review, and it looked like it was all good. But part of the power of attorney said that it was a elderly person that was needed to be cared for, was part of the owner. Somebody had died. One of the owners was somebody in a care home. His daughter had gotten power of attorney like a year or so before the sale. But part of the power of attorney guidelines is that a doctor needed to sign off on when that person became incapacitated. And so they needed to have doctors, whatever. And so an angry in-law came into the munch and did another power of attorney right after that. And I'm like, so I had two competing power of attorneys, and like, which one's valid? But the whole thing was about the doctor's note. The doctor needed to sign off that this person cannot make decisions for themselves. The first power of attorney never had that done, so it was invalid. So then we had like an emergency power of attorney come in, which was a third sibling, court ordered, and it was such a mess. And I appreciate Shannon's help on that. But you know, it's not up to us to interpret power of attorneys, but just look for that and ask, like, hey, did you guys get, is this valid? Ask. Otherwise, because this is like a 6-month close of escrow because we had two competing power of attorneys.
And the challenge, had the courts not made the decision on that, of course, the challenge is now to do a second one. The person's getting a doctor's note that says they're not competent to sign anything. Well, how do you get another one if they can't sign?
Exactly.
So you're kind of in that weird space, and that can be a challenge. So thankfully the courts did step in on that one and handled it. But yeah, I mean, those are the kind of things. And then Jody, correct me if I'm wrong, but my understanding is that if there's a trust, oftentimes you can't have a power of attorney signing for the trustee unless the trust specifies that it allows a power of attorney to sign for one of the trustees, correct?
That is correct. And it is, and on that, you're not going to find that in your certificate of trust, which is a 3-page document, you know, that we typically request. That's going to be in the 125 pages somewhere in there. It's going to talk about that.
Right. So moving to trust, let's talk about that for a second. So on the trust side, you know, again, what Jody mentioned was the certificate of trust, which is what we're looking for. If you know, when we flag your sky slope file, you turn in a file that we see there's a trust and someone has signed as a trustee, that we want to see that certificate of trust to confirm we have the proper people or everyone that needs to, because sometimes you might have one trustee, but you actually need to have both, or maybe a successor trustee on one side, you know, who knows the situation. So typically that's all we're looking for. We don't need to see, or because we get that a lot, we don't want to get into everybody's private business, you know what I mean, in terms of a client, to go that far to see who they're leaving everything to and what they have. But title might need that in, like, and to Jody's point, at some point. Now, yesterday, I was in Bob, I think you were there, and Monique, watching the homestead class that the government affairs did over at We Serve, and they were talking about, they suggested getting an identity statement form filled out. So you guys know, during escrow, title company typically will send the seller an ID statement so that they can search payoffs and, you know, have their authorization and all those things and confirm names and that kind of thing. Well, yesterday they suggested this, I thought it was a great idea, was to get a copy of a blank identity statement and have your seller fill that out at your listing appointment. And then that way you can get that ahead of time to confirm if there might be something else you need. Do you have thoughts on that, Jody, or any?
I think that might be a little bit harder for you guys to get, just because you're gonna, the items we're gonna want, social security numbers, dates of birth, driver's license numbers. I
Mhm.
think it might be a little bit more challenging for agents to get that and for people to feel comfortable. I
Mhm.
will tell you, like, those are items we send out in the beginning of every transaction. We do have to have that information.
Mhm.
And I mean, I just don't know how that would necessarily help to know who can sign on
Okay.
behalf of an entity or a trust or anything like that. Just because, I mean, the problem is people can put false information anytime.
Right, right. And I don't think people intentionally do that. I think a lot of the general public just doesn't know. They don't understand all the nuances of these things. And unless they have an attorney or someone guiding them through these situations, or someone they can refer to, they just don't know. They think they can sign, mom and dad gave me power of attorney, I'm good, or whatever the situation is. So, my point is that researching this ahead of time, sending it to title to let them confirm if what that person has is valid or not is just very important. Lynette, did you want to share a story? You said you have a durable power of attorney story. Are you still on here?
Sure, and of course I'm out walking my end. It's a little windy, so I apologize. Can you hear me okay?
Yep, you're fine.
So yes, now this one was up in Washington State. Same thing. This is a durable power of attorney. So yeah, sister started becoming, she started getting dementia, those types of things. They actually had set up can you hear me okay? Sorry.
Nope, you're fine.
I'm still construction zone around here too. So anyway, they had set up a durable power of attorney a couple years prior, knowing that she's like, you know what, I need to get these things in place because yada, yada, yada. So when I sent the durable power attorney and the doctor's note over to my favorite escrow officer, she sent it over to title, and title said the doctor's note doesn't specify at what point she became incapacitated or couldn't make any decisions any longer. So we can't verify that the attorney drawn up power of attorney is authentic according to the dates at which, and so my client freaked out because she's like this doctor's gonna do that, first of all, go back and then why wouldn't an attorney sign off on a power of attorney if the person wasn't of a competent mind at the time that they signed it? So needless to say, I found a different escrow company altogether, and they were fine with just the power of attorney. They didn't need the doctor's note. So, and then your question about the questionnaire for the title company, I think just like you said, getting ahead of the information and just saying, hey, you're going to be getting this from the title company. Make sure you fill it out as quickly as possible, or at least kind of show them an example of what it looks like, what to expect.
Right, agreed.
That's all I got.
Yeah, thank you. No, thank you. The other one that comes up obviously are LLCs. And I'll be honest with you, I know a lot about LLCs and I understand them, but I'm not an attorney, obviously, and I'm not a title person, but confirming who can sign for the LLC. And sometimes there are partnership agreements and things that are not recorded with or online with the Arizona Corporation Commission. The articles of organization may or may not stipulate. So again, it's one of those things where getting ahead of that, getting that person in touch with title to confirm they have what they need and the right person is signing is so important. And obviously this is typically it's important on both sides of this, but on the listing side, when you're meeting with the seller that first time. On the buyer side, you're kind of relying on the other side having done all that same research, but it certainly can't hurt to look those things up when you're representing a buyer and getting ready to make an offer, so that if there is even a potential challenge, you can question it ahead of time and just ask that listing agent, did you get this? Or do you have the certificate of trust? Or do you have the proper power of attorney for whoever you have that one is wanting to sign this? Those kind of things ahead of time. So again, you're not running into that at the last minute and trying to clean it up. Oh, Sarah, you have a question about trusts? A doozy coming up, you said?
Jody knows a little bit about this story, so I'll make it short because it's long. My concern is making sure that I have two sisters. One, they're both from Canada. One has American citizenship, but she's not the signer on the trust. The sister that lives in Canada is. And so dad went to Costa Rica and passed away there. And so now they're dealing with starting to sell these two properties. So is there anything I need to look out for as far as the sister being from Canada and making sure that she's the appropriate signer on the trust? Is there anything I need to be looking for?
I don't think it changes anything in terms of,
Okay.
Jody, maybe you can pipe in on that. I don't think so. I mean, I don't think it makes any difference where she's from as long as she's the authorized signer, you know.
Okay.
Now, I don't think FERPTA or any of that comes into play because if the trust is in the US, that's the owner. So I don't think that's an issue. Am I correct on that, Jody? Anything?
Correct. We look at a trust as it's basically its own entity.
Right.
So as long as it's a US trust, then FERPTA would not apply. As long as the trust states that she is the successor trustee of the trust, then she can sign on behalf, and it doesn't matter where her citizenship is.
Okay.
Right. Okay.
And- okay. Yeah, this one's got all kinds of fun stuff. There's IRS liens and tenants that's squatting in there that they got to get out. And it's yeah.
Right.
It's a doozy. So poor people heard the dad. So the dad had a visa to work in the United States, but he was also Canadian. So then he went to Costa Rica, left his properties to some lady named Peggy to be the property manager / landlord. And she's literally renting these properties out for $350 a month. And then he goes to Costa Rica and has nothing in writing and then dies there.
Oh,
So
geez.
it's been, yeah. And one of the properties has like $180,000 lien against the IRS on it. So yeah, and they can't get a hold of anyone at the IRS, which is a whole other issue. So I don't know, Jody, if you have a back line to the IRS that you can give us, but they can't get a hold of anyone. So yeah, it's a hot mess. So
Sarah, I do have someone for you on that. At the
Okay.
IRS. Yeah, we've had a
That would
couple
be
situations where we've had to get a hold of them, and we do have someone. So I'll get with you after
thank
this.
you. That'd be great.
So the next thing I just wanted to show you, and Jody actually showed this to me, and I'm gonna share my screen again here. Again, you guys know me, I'm not the techiest one in the bunch.
While you're doing that, I just wanted to mention in regards to LLCs, something that would be great if you could get ahead of time and ask for is an operating agreement. It's not a document that's going to be recorded. It's not going to be with the Corporation
Right.
Commission. It's a separate document that your clients should have if they have an LLC. I would definitely recommend asking for that because that's going to state who can sign on behalf of the LLC. If they're
Right.
managers, if there's members, it'll talk all about that in that document. So that's definitely something I would ask for. A lot of people don't have those, especially if it's just like a smaller LLC where it's just like just two people or something along those lines. If it's something where it's similar to like, okay, you have, John and Jane Doe with that, and they don't have an operating agreement, we are going to require that both people that are on the LLC sign all closing documents.
And it was just, that's what I was gonna say, is not everybody has those operating agreements. And I know, hope he doesn't mind me sharing this, but with Frank, obviously I helped him for many years on his LLCs. We basically at one point took all of his LLCs, went and had an entity signer agreements done for each one. And then we just kept that on file with like TAP and whoever his preferred title company was back then even. And then they just had it. So every time he sold a property or something, they had that on file already. So if you have an investor client in that situation, that's something you can do as well. Well, Lynette was asking, what is that operating form called? It's operating agreement. Yes. Yeah. You have your articles of organization, which are we're going to look at those right here in the Arizona Corporation Commission, but the operating agreement is not always recorded. And that's the one they can also be a partnership agreement or operating agreement, either one. So let me try to share this here, my screen, you guys, and we're going to look as if we are in MLS. So I pulled this property. So just because I knew this situation, so you're in your listing, you go to Monsoon, and we're just looking right here for this name, and then we assume that's who is the owner. The challenge is, and then Jody has shared this with me, that they're seeing a lot of Monsoon not being accurate and not being current. And so what she suggested is to make sure you're going to the actual recorder's office and the county assessor's office to find out who the actual owner is. So in the past, I used to go here to Monsoon. I'm just going to share this. I would go down here to the deed history. I would look at the most recent one or some involved if it's depending on the people that I'm looking at. And I would go here, click through, and then you can see those deeds. And to give you an example, so you would see these names. You see Walter Schmitz, you see the trust that it from him, that sort of thing, and you can go right through to there. Let me go back up here though. But Jody was showing me that because this is not always accurate, and therefore that might not be accurate, your deed history, that it's a lot safer to actually go to the assessor's office. Now, I used to do this and just click down here under county treasurer. It would take you here. You would put in the parcel number, 200, what was it? 84926. Which one was I on now? No, here we go. And I would search here. So you can go to, you can confirm the name here. You can go to the tax details and see it here. This is different than what Jody showed me though, which is way more accurate and a lot easier. And I'm going to close a few of these tabs so I can show you. So if you actually go to separately to the assessor's office and you are on the home screen here, you can search by address, parcel number, anything. So in this case, I put in the address, I search it, and I get an entirely different view of the assessor's information, and I'm not sure why. The benefit of this one is that it has the deed recorded. Is that, Jody, the right place that I should be looking there? Is that right? Okay, so you can get a little more information there, and you can see again who from the actual recorded information, the most current deed, the most current name that should be using in the ownership. So again, you can see that same deed there. But if that hadn't been accurate, it would potentially be different. So everybody follow that. So again, instead of clicking from Monsoon, go to the actual assessor's office, then go to those recorded, because that will then take you to the recording office's recorder's site as well for the most current one. Does that make sense? And am I the only one who didn't realize that looked different? Or is that just me? When you
No,
go
not,
and
not just you.
yeah, I don't know why it would be different, because this is, when you click this, it is the treasurer's office, it's the same thing. So I'm not sure why we get a different view or a different site entirely. But this one is obviously, and I don't know if it's that because it's a John Allen treasurer.
So the one that's going from Monsoon is taking you directly to the treasurer's office, which is
Instead
strictly
of
just
the
for taxes. When you go to the assessor's office, that one that you're on right there, that is giving you the recorder's office, the assessor's office, the treasurer's office. It's giving all of them in one location.
Okay, perfect. I wish Monsoon would link to this instead. That would be nice. Which may be why Monsoon is going away soon. If you guys heard me talk about that on a recent broker blast, that Monsoon, they're going to be replacing it with a new program. So, and I think it's because so many times this is not accurate. So you just can't rely on this. You have to go deeper and you have to confirm by reading those deeds. I had pulled up, where did it go? So on this one, for example, I'm going to go back a little bit. So I'm going to go back to the one that's the old trust a couple owners ago. And I just want to show you this because this is where, when we talk about a trust name, this is the owner of the property. This, as the trustee, is the person who can sign for that entity. And I think that for whatever reason, there's still a lot of confusion on that in terms of who actually is the owner of the property versus who's signing for it. Because we still see contracts that have that wrong. So, and it's really important. I mean, if you think about it, it's as important as I can't just go and sell someone else's car. I have to have legal ownership of that car in order to sell it and transfer it to somebody else. It's no different for a house, and way more important, obviously, in terms of what we deal with, which is why it's shocking to me oftentimes to see how loosely people run with this and don't get proper signatures or don't have the names spelled out correctly. It's just critical. You know, I used the example recently of when we're, and I'm gonna stop sharing real quick here. Maybe, there we go. When, if you've ever signed for loan docs, you know how I'm gonna say nitpicky they are in terms of you can't miss an initial. You have to, you know, sign exactly as your name is legally or how they have it on the docs, all those things. It is no different with the contract documents we work with. These are legal documents that we have to be equally as careful about. And that's why, you know, I keep hammering this home because it's a challenge. And again, what I'm hearing is that there are people out there who, when they get cold feet, or maybe you have a seller, for example, who's decided that they can get more and they just want out of the deal, which we're seeing a lot of that because they're seeing, oh, I can get this next offer that's 20,000 more. How do I get out of this current contract? Well, if something is not signed properly, they're taking that to an attorney, and the attorney's saying, you don't have an enforceable contract because the proper ownership or the proper entity or the proper person who was authorized didn't sign this or didn't sign it properly, and they're using that. So it's just really important and to be really careful with that. Lynette was asking, is there a benefit to having a couple have two separate trusts? I don't know the answer to that, Lynette.
Yeah, I'm
Jody
just curious.
probably-
Like I had a closing, and it was a husband-wife couple.
Mhm.
So they were both trustees on each other's trust. So they had to sign two trust paperworks when they purchased the house because they keep their trust separate. I'm sure it's because he was in law enforcement and she was a nurse or something. Maybe they thought in case something happened to him, she would still have, I don't know. I'm just curious if there's actually a benefit to that.
The only time that I see it is if it's, you know, wealthier people, that they'll have it for tax purposes, but I don't see that there would be a benefit just because of the fact that if you're married, you know, people can go after you, both of you. My husband's a police officer and we have a trust, and it's a joint trust. So the only time that I've ever seen two separate trusts is if it's somebody that's, you know, has a lot of assets and funds, and there's tax reasons behind it.
Yeah, that could very well be because they own property up in Oregon too that's worth over $1 million. And yeah, that makes sense. Okay, I was just curious.
Okay.
Because it confused me, because I know when I sold their other property, there was only one trust in place, and now they each have their own. I'm like, okay, whatever.
Sarah, did you have a question or did you raise your hand? Okay. So is everybody comfortable that instead of using Monsoon, go to the assessor's office, search that address, and then start looking at the actual ownership, the deeds, making sure you have everybody that, you know, Aunt Margaret from Wisconsin is not still on title somewhere with somebody. Quick claims are a red flag. Ask your title company to check that. If you are at a listing appointment and you start doing this research and you see that there was a recent quick claim and it wasn't done, say through a title company or that way, what I'm hearing, and again, Jody can probably piggyback on this, is that a lot of title companies are not ensuring that. They want that to be redone or have that person who quit claimed off, they want them to sign an affidavit of some sort and get that done during escrow. Well, what if that person's long gone? We had a situation where it was an ex-girlfriend. You can imagine she wasn't super excited to say, oh, I'm going to sign off on this, and now I'm going to make his life difficult, and I want some of the proceeds, and I'm going to hold him hostage until he pays me to sign this affidavit. We've had those kind of situations. So it's just really important to even look a little bit further to see how they took title and was it done properly, so that it's not something that has to be cleaned up later. You can address it ahead of time. Jody, do you have anything more on that you pipe in on or share?
No, the affidavit of uninsured deed is what we would require if it was a quitclaim deed. Any type of deed that's uninsured, honestly, even if it's from a husband and wife going into their trust, and it's done by a quitclaim deed, we have to get an affidavit of uninsured deed signed by them. So that's the biggest headache for everyone, is if there is a quitclaim deed from, a certain person to, like you said, an ex-spouse. And I had one actually yesterday that it was an uninsured deed. It was from a divorce situation. Fortunately for us, the divorce decree stated that the wife got the property. But if the divorce decree had not stated that, we were going to have to try to locate the ex-husband, which nobody knew where he's at, and request for them to sign an affidavit of uninsured deed, just because it's such a high title liability for us.
Mm-hmm.
So definitely, if you would look at, the previous chain of title, who acquired, how did they acquire title, just to see, and if that is the case, if you see that it's not from a title company, ask, okay, how did you get this? Do you still have contact with them? Because every title company pretty much now is requiring those affidavit of uninsured deeds.
Right.
Hey, can I add on to that about the divorce decrees? And never assume that it's 50-50. Because if somebody's still living in the house, I had this situation a couple years ago that the husband was taking out loans. And so it wasn't a 50-50 split. So I had both of their attorneys contacting me, which scared the crap out of me because, I wasn't able to talk to my clients anymore. I was talking to their attorneys. And so it was more like a 70-30 because they had to fight it out. It wasn't 50-50. And I made that mistake in making that assumption. I didn't know. I mean, I saw the decree. I didn't think to ask further on. And so that was a nice lesson that I had to learn. Yeah.
All right. And does everybody understand when Jody mentioned on how to tell if a title company did that previous deed in terms of insured it or not? Is it typically, and Jody, correct me if I'm wrong, and I'll share my screen here. Typically, if I can find a document, it would be here. Is that right, Jody?
Yes. Yeah. So like that one is an uninsured deed.
Okay. Interesting. Yeah, this is one of our current transactions. So that's where you would look to see if it's, First American Title here or Title Alliance, Title Alliance or whoever it was, then when it's recorded and who prepared it there. The next thing I wanted to show you guys, so again, the takeaway from all of that is to go to the assessors and start digging and paying attention to everything you're seeing and just, and question it. If you're not sure, just question it because it can't hurt to find out up front. The next one is to go to the Corporation Commission to check on an entity. And mind you, this is if it's an Arizona Corporation Commission, I think it was a Delaware that it can be, it's not out there in public, I think, if I remember correctly. But if you go to the Arizona Corporation Commission, you can search, and I'm going to use Frank as an example just because I know his. You can just put in his name or the entity, the entity LLC. You can look up here, start clicking through these links, making sure it's in good standing. I've run across recent ones that were not in good standing, which caused an issue. You can go and see who the members are here, but I always try to go further than that and go to the document history or even pending documents, because if there's been a change that's not reflected on that first page, or it's just kind of like Monsoon, not been updated on the first page, you don't want to just simply rely on that. You want to go actually to the articles if you can here, or the most recent amendments. And then you can start seeing who's the statutory, where's their address, who's on here, who are the signers potentially, or at least, if it's one person or not, or maybe there's someone else that needs to be questioned, again, might be in the operating agreement or a partnership agreement. But at least then, if this was the case, I would, and I was on the other side, I'd say, is Frank truly the only signer, or what about this other person, Leanne? Where is she? And if I don't have her signature yet, if you're on the buy side, for example. But you can start looking here. I've actually had situations, on these where you have licensed parties, for example, who didn't disclose their licensure, maybe they weren't the original signer, but they're on the entity and they weren't disclosed, or we dug into one. We had a little bit of a nightmare one time where we started digging into it, and as the entities were all member managed by a different entity, and as it got down to it, it was all the same people all the way through, and it was actually, it was a divorce situation and it got a little ugly, but then it turned out that the wife was notarizing these for the husband, and obviously those were challenged, so they weren't valid. So you can get into a lot of things. You just, if you're not sure and it doesn't look right, or there's a name on there that nobody has seen a signature from, or you've never heard them mentioned from the other agent or from your seller, you might want to start questioning those things right up front. So any thoughts or questions on any of that? Yes, Frank does need to update his address. I saw it too. I was going to mention that to him when I pulled that one up. She would need to send a disclaimer deed, which would also be required by the lender. Yes, yes. Any questions on where to go? I mean, my biggest takeaway for you guys on all of this is to just dig and know where to dig and start poking around those links, because it's amazing the things you'll find and the things that will come out that ultimately usually need to be addressed. Nate, you have a question?
Okay.
Yeah, I'm on a Zoom call.
Oh, he's just sharing. Any questions on where to find any of that? Warranty deed would have a title company in that. Yes, thank you, Jody. So Jody was just in the chat there mentioning that warranty deed, again, the deed that's in there will show that title company up in the corner there. And if it's not, then again, that's something you want to take to your title company ahead of time and have them start checking. Jody, in terms of running title ahead of time, so you're taking a listing and you want to have your escrow company or your title company run a chain of title or a prelim, is that something you guys do, or is that common practice at all for anybody?
Yes, we do that all the time. There's a couple of agents, Danielle's one of them, Chris Dubricky. They typically will request for us right when they take the listing for us to go ahead and do our title search already with a buyer to come. Especially if you have just a funny feeling that maybe there might become something coming up on the title commitment, any requirements that need to be cleared, we can get those done ahead of time. And that way, when you do get your contract in, it's a smooth closing. There's no hiccups. So we definitely can do that.
I think that's a great idea. And I think, and I know I'm sure Chris wouldn't mind me sharing, but because he does quite a bit of probate work and he has a lot of that is his sphere. I know that's critical for him in those cases. Which, speaking to that, I think to the point of preparing, like, even if we don't, again, get that ID statement up front, preparing a seller of what they're going to have to fill out and what they're going to need to provide. That entity transfers paperwork I was showing you, to show kind of here's what title is going to need. Just letting a seller know that, so that they're not feeling, because people get a little sensitive about this stuff sometimes. They feel like it's a privacy situation, or they get nervous about providing those things, death certificates. Sometimes it's just an emotional situation. So just gently preparing them for what they might need to provide and having that stuff ready. I had a situation recently where a seller didn't realize he was going to need to provide that death certificate. And so, going back to get an original, and you do need the original, correct, Jody?
We do need the original. And I was just going to give you a really quick example of the death certificates. It's a very sensitive subject, and we do tread very lightly when we request those from clients. But for instance, I have a file right now that the seller had community property with his wife, community property with rights of survivorship. Wife passed away, husband passed away, and now son has personal letter of representative to sell the home. When wife passed away 20 years ago, they never recorded a death certificate. Now they can't find her death certificate. son can't find his birth certificate. And so he can't get a death certificate for his mom until he can get his birth certificate. So we are in the process of trying to get a death certificate because they didn't record that death certificate when the mom passed away. It doesn't transfer the ownership over to the dad automatically because we don't know necessarily that the mom has passed away. We know now that the dad's passed away, but we don't know for sure that the mom's passed away because there's nothing recorded. So people just don't understand that sometimes. Well, why are you requiring this? Mom passed away 20 years ago, dad passed away 5 years ago. Well, you're telling us that, but we don't have anything to back it up.
Right.
So
Right.
those are just like, I didn't know about that. I didn't realize like, oh my gosh, yeah, he has to have a birth certificate to verify that that is in fact his mom. So that can be a challenge, especially in today's world where he's back in New York. Nobody's in, and his birth certificate comes from New York. Nobody's working in the office. And that turnaround time is 3 months for him to get his birth certificate. And then you have to come here and get a death certificate. And that's, a couple weeks at least.
Yeah, I was just thinking back, I had to get one time. It was pain. And that was when things were a lot easier. So questions that we had in the chat here, can a seller have a death certificate recorded prior to going on the market?
Yes,
And
they can.
Sounds like you'd recommend that, right?
They can definitely do that, but also we will do that at closing. So we just kind of do it in order of succession, but no, they can definitely have a death certificate recorded prior.
Okay. And then the next question was, how about a death of a spouse when house is deceased spouse is sole and separate? Can house not be listed until surviving spouse is appointed personal rep, or can it be listed in escrow and pending that certificate? So, my understanding is that it can't be because they don't have that authority yet.
Correct.
You would again potentially have an unenforceable contract because you don't have the proper people with authorization to sign completed yet. You can't make it contingent on having that, if that makes sense.
I just want to state one thing really quick in regards to letters of personal representative. And some people don't actually know this. Letters of personal representative are actually only valid for 60 days.
Oh.
So, and that is a law. So anytime we have one that was from 2020 and they feel like, well, nothing has changed. Those personal letters of representative are only valid for 60 days. So you have to go back to the courts and get a new letter of personal representative every 60 days.
I was not aware of that. So for example, if someone doesn't sell within that 60 days, then it's maybe it's a longer escrow or something, they have to go back during that time.
Yes.
Oh, interesting.
You can sometimes get, we can, if let's say it was already put into escrow and the letter was valid for, 45 days, and then there was a delay of, a month or something, I can usually get our underwriter to approve those.
Mm-hmm.
But if it was not put in escrow and that letter is only
Already expired.
Yeah. Or even if it was only valid for another 5 days, let's say, then unfortunately they would have to go get another letter of personal representative. Interesting.
See, I learn new things on this every day. That's new. I didn't realize that. Letters of personal representative as well. We had a situation, I'm just going to share a story about this, where property was listed. The seller was incapacitated, had a power of attorney for a family member. Family member was signing for it. The person actually, the incapacitated party actually ended up passing away. That power of attorney then essentially, for lack of a better way to say it, dies with the person. So then the power of attorney then had to go through probate to get a personal representative assignment so that they could actually still sign forward. And so that's something to be aware of as well. And I don't know, Jody, what would have happened, say, if we had been in escrow thankfully we weren't at that point, it was prior to, but had we been in escrow when that happened, what happens then?
If the power of attorney was in effect and all the documents were signed, so all the closing documents were already signed, then the person passes away, then we can still close because it was the intent of the person that passed away to sell that property.
Okay,
But, and when I say that, like, everything has to already be signed, we're closing within a day or two,
okay,
and we can still, use that power of attorney. But if you're in escrow and we haven't got, we're only in escrow for a couple of days or anything like that, then that power of attorney is no longer valid. And
Right.
you would require a letter of personal representative. And I will say a letter of personal rep, it doesn't, if there's no major family issues or outside influences, you can get those within a week. Those they don't take very long to get.
okay. So I had heard they were taking forever, so that's news to me as well. Do you have someone that you recommend that we send a client to get those done?
I recommend a lady by the name of Tracy Marsh. She actually does a lot of probate. And so she's somebody that I recommend, but like, I can tell you, like, my mom, who is not computer savvy, is not legal savvy. When my dad passed away, she actually got the letter of personal representative herself. She went to the courts and, she had, at the time she had the will that her and my dad had signed. And she was able to get the letter of personal representative. And what is required when you do a personal rep letter, it is required that you open an account, a checking account or a savings account in the name of the estate.
Right.
That's where your funds are going to have to get transferred. And so that kind of protects everyone is, if they're while they're going through the probate process, you can't use those funds. They're just going to sit in that account.
Okay. That is a good point. And I thank you for mentioning that, because that's come up a few times as well, where there was a little bit of a scramble right there at the end because someone didn't realize they had to have the account for the proceeds to go into on a personal rep. And to that same point, when someone has a will, that doesn't mean it's automatic. In Arizona, they still have to be appointed as a personal rep. So they still have to go through that process in order. It can't just be that they have a valid will.
Correct. The only time is if the home is in the name of the trust.
Mm-hmm.
And even that goes further. Let's say there is a trust, but the home is not in the name of the trust. You're having to go through probate, even though they had a trust and they forgot to put the house in the name of the trust. And then just really quick, just something that I want to point out to everyone is if you have an LLC, if you have a trust, if you have an estate, the accounts for your proceeds, and this is just me just bringing this up, it doesn't really have anything to do with the actual documents, but all of your accounts have to be how title is vested. So if you're vested in an LLC, you have to have an account, a checking account, savings account in the name of an LLC or your trust. Otherwise, we have to cut a check and then you have to go and try to open an account. Your clients would have to go open an account. So that's definitely something to bring up to your clients when you're doing the listing. And then you see that these homes are in these specific names, is to just mention to them, just so you know, do you have an account in your trust? Because you are going to be required to have the funds in the name of your trust. And it just saves a lot of headaches for everybody at the end.
Right. Because everybody at that point is either trying to move or make arrangements for things to be moved. Maybe it's a family member from out of state who's trying to do this, and they're trying to have estate sales and different, depending on the situation, that can be really stressful and a lot of times often emotional and sensitive, depending on how long it's been since someone passed or, whatever the situation. And any of those hiccups cause an issue. So the more we can do ahead of time and proactively to prep them and or address those things before it gets down to crunch time, huge help. And we should be servicing our clients that way. Can we please get an email with these bullet points? Yes. And I will resend that. I'll just follow it up as my broker blast this week and send those out to you guys, both the entity transfers, the sample signatures, and some bullet points of everything we've discussed here. Any other questions or concerns or anything anybody's run into that you have a question about?
Can you go over the appraisal shortfalls? Explain that.
Oh, this is not on topic, but I just had someone ask me because it's come up a couple times this week about appraisal shortfalls. They're coming up a lot. again right now, you guys. This is a side note. And that language in the additional cause addendum for the appraisal shortfall that came out last year. So this is that case where a buyer is saying, I will pay, up to, so if we have an appraisal that comes in low, I will pay up to $10,000 of that difference or whatever that is to sweeten that deal to, so that if there's a concern that they're kind of overbidding on a property and that appraisal may not come in, that they've got an amount that they're offering right up front that they would have paid towards that. One of the questions, or what's come up a couple times this week, is whether or not that makes any difference if they're putting a down payment down. Meaning, so if the appraisal shortfall is say 10,000 and they were already putting 30,000 down, does that make any difference at that point? And it does, because the appraisal coming in at the purchase price, the appraisal contingency is always based on the lender accepting that appraisal for at least the purchase price, because the loan to value, if they've got a down payment and they're doing a percentage, is all based on that amount that it appraises. And so when it comes in low, even if they're putting that larger down payment, they still need to stay within that percentage. So it might decrease a little bit, depending on the percentage, but they're still going to have to make up that difference in their down payment with the actual purchase price. Does that make sense to everybody? And any questions on any of that? Sarah, I don't know if you want to share, kind of what your thought was as your question when you had that come up.
Well, I think we talked about it yesterday, is that if you're putting down 20% or more, then it changes how the lender looks at that, right?
Right.
So, and that's what I confirmed with the lender too. So just gotta be careful how you word that stuff, because I've had conversations with several of our agents, and I don't think people are clear on what we're obligating our clients to when we put those shortfalls in there. So.
Right. And I think the easiest way to think about it in my mind is that you think about it exactly like an appraisal contingency. It's no different. The same rules apply. That difference has to be paid by somebody. It's just how much are they automatically agreeing to pay versus the whole thing, if they're going to move forward, if that makes sense. So a little bit off topic, but I wanted to mention it because I have had it come up a couple of times just this week even. And it does sound like there's a lot of confusion, and we're back to using a lot of these tactics to get properties and get buyers offers accepted, because it's crazy out there again.
Can I just say one real quick thing on that VA or on the appraisals? I had this come up and taught me a lesson in escrow, and it was a VA loan. They had the appraisal shortfall contingency, and appraisal didn't happen. It didn't come close to what they had offered. And even though they had that appraisal contingency shortfall, the buyer was able to get out of the contract
and
still get his earnest money back, because it doesn't matter for a VA.
Or FHA.
I was going to say FHA too. So
FHA is the same. That little line in the contract that says, unless otherwise prohibited by federal law, you can't trump federal law. I mean, we've talked about that is beyond anything my example, we can agree to shoot each other does not make murder legal. So, we can agree to have that shortfall, but a federal law says you have the opportunity to cancel and get your earnest money back. You always have that opportunity as a buyer. So, yeah, great point. Great point, because it comes up a lot. And everybody gets a little grumpy in those situations. And especially when a client doesn't understand and you've told them otherwise, thinking that they were going to have that automatic, no, if they cancel, we'll get the earnest money. Not true on FHA and VA in particular. Any questions? You guys were right up here at 10 o'clock. I know this was more of an open forum than a class, but I think we covered a lot of things, and I will send out a follow-up email here and a broker blast with some of the links to the things we've talked about. But any questions at all last minute here? Everybody doing okay? All right. All right. Well, thank you guys. Appreciate you. And if you need anything, don't hesitate to reach out. Bob, I will get back to you on the homestead. For those that weren't there yesterday at the government affairs, there was a ton of information presented, and it's still a lot of a mess. So yeah, we're all trying to sort through, trying to figure that one out. So anyways, Jody, if you ever get anything new on that, let us know.
It's still a mess.
It's gonna be
Hey,
interesting.
Shannon, I sat in on a clock hour class 2 weeks ago about that homestead. It was, sorry, until I just got back from my walk and my mess. Anyway, they filmed it. So if you want, I could send that to you if that's something you want to share.
That-
And
I
it was,
would
it
love
was,
that.
it was done by an attorney. So
Yeah.
yeah, I'll find that and send it over to you.
I think I've sat through at least 3 of them now, and I still, every time I have new questions because someone someone brings up another situation I hadn't thought of. So there's a lot of holes in it. It's hopefully they get it cleaned up this year, but in the meantime, we all have to deal with it somehow. So
Yeah.
anyway, all right. Well, thank you guys. I appreciate you. If you need anything at all, don't hesitate to reach out. I hope you guys have a great week.
Bye, everyone.
Bye.
Thank you.
Thanks.
Thanks, Jody.